SMS Edwin Tong.
Thank you, Mr. Speaker, and I thank all the members who have spoken in support of the bill, and I'm grateful for the strong support that have been expressed in this House. Members have shared many examples of how Singaporeans and animals, some known personally to them, have experienced harassment both in the physical and online space. I will do my best to respond, but I can't reply to all the examples that have been cited, some more graphically. But the stories that you have told, you have shared in this House, illustrate just how easy it is to spread falsehoods about individuals, about businesses, and how there are serious consequences, immediate and downstream, and why we need this bill to give redress and to recourse for individuals against physical and online harassment. Mr. Walter Teixeira shared a very vivid and, might I say, graphic example of his own personal experience of being harassed and spoke passionately about the need for each of us to treat one another with dignity, offline as well as online. And I cannot agree more with Mr. Teixeira. Members have vividly described falsehoods which have serious and devastating consequences and which can also have a deep and long-lasting impact. They underscore why we need these laws. The questions that members have raised can be categorized into various baskets, and I intend to address them as comprehensively as I can. First, let me address the court process, which various members have touched on. Ms. Anthea Ong has suggested to allow persons between 16 and 21 years of age to make applications for protection orders without their parents or legal guardian. We recognize that in some cases there are groups who might require assistance to seek legal redress and for their own reason may not want the parents to be involved or to be aware of it. That's why Clause 24 of the bill permits prescribed third parties, such as voluntary welfare organizations, to bring civil proceedings on behalf of the victim. The court will consider each of these applications judiciously. These third parties, on top of being able to bring the application, can also give practical support to the victim by providing information on court procedures and processes, and also help, especially at an important time like this, on lending emotional and moral support to the victim during the process. Mr. D'Souza and Ms. Rahayu asked whether there are measures in place to ensure victims of harassment and abuse are given sufficient assistance when they approach the courts. Ms. Rahayu in particular expressed the hope that the PHC will also be a one-stop shop to provide practical support and help with counselling. The current laws, augmented by the proposed revisions in this bill, strive to make the process as easy as possible and as simple as possible for the victims. Currently, there are already court officers at the PHC, the Harassment Court Registry rather, to explain the process under POHA. There's also an assessor stationed there to look at the application, understand the nature of the application, and guide the applicant on the application. On top of that, immediately options are also put to the applicant in the appropriate cases to consider counselling or mediation. On top of this, on a pro bono basis, law students are available to assist on-site to provide general advice, to help with the form filling, and to provide also, in the case of more complicated, factually involved cases, to assist in the drafting of affidavits in the application. Currently, the court already has the power to refer parties to counselling and mediation and will continue to do so in the appropriate cases. The streamlining of procedures and expedited timelines that I mentioned in my earlier speeches build on this and to enhance the process even more. In relation to police investigations, Mr. Lewis Ng asked if victim care officers who are specially trained in victim care management also handle the cases involving victims of harassment. The answer is yes, they do. The Victim Care Cadre program is available to all victims of crime who require emotional support throughout the course of investigations. This includes victims of harassment who can avail themselves of victim care services by providing their consent to such services in the case of the investigation officers. Mr. Ng asked if it's possible to make it mandatory for the court to refer parties to mediation and counselling. I think I've addressed that, but just to underscore the point, under Section 12(2)(b), in appropriate cases, the courts already do so. They have the power, and they do frequently arrange for parties to attend counselling and mediation when it is appropriate in those cases. Ms. Ng also asked if it's possible for social workers to be attached to applicants of POs in certain cases so that a social worker can consistently monitor and be aware of the development of the case and also be able to identify worrying trends or changes in the harasser's behavior. The case which Mr. Ng cited is a tragic one, and I would say that there are already existing avenues for applicants for the POs to on-site counsellors and also psychiatrists who will be able to assist. Separately, the amendments will ensure that a respondent will be ordered to undergo a mental health assessment and also the appropriate treatments where necessary. But nonetheless, Mr. Louis Ng's suggestion is an interesting one, and we will work with the relevant agencies to see how we can further consider this suggestion and also enhance the support to victims. Ms. Rahayu asked if there are plans for the PHC to employ a judge-led approach. The short answer is yes, and Clause 24 of the bill empowers the PHC precisely to adopt a judge-led approach in any civil proceedings before the court. This will ensure that the judges will exercise greater control over proceedings, taking charge of the proceedings and managing it from the judge's perspective. The overarching objective of this is to ensure that the proceedings are dealt with as efficiently as possible, fairly, but also to ensure that acrimony is kept at a lower level as possible. Mr. D'Souza had asked about the timelines and asked how long the process to apply for PO and APO currently takes. He also asked what resources will be deployed to the PHC to ensure that the proposed timelines that we have in mind can be met. Currently, an application for a PO is fixed for a pre-trial conference about 3 to 4 weeks after the applicant's originating summons and affidavit are filed and processed. The hearing for the final PO is generally fixed within 4 weeks from the last pre-trial conference, so it will be several weeks or if not months downstream from the original application. Applications for APOs are fixed for a hearing before a judge within 3 working days from the date these documents are filed. We will work with the state courts to ensure that necessary resources are deployed to expedite the hearing of these applications. That's the intention of the PHC in the first place. Having a dedicated court to hear these applications with streamlined procedures, applying them in a way that best suits the case will make for expedition and also efficiency in managing the cases. Mr. Singh asked about a case where, on occasion, you might need to hear a case in 5 to 6 hours because of very pressing demands. No doubt courts will try, but I would say that it will be very difficult to do so, mainly because to hear a case properly, fully, one will have to ensure that the proper evidence and the right materials are before the courts, for the courts to make a proper assessment of the case and decide. Mr. Murali asked about the jurisdiction, and I'll just like to deal with that, the civil jurisdiction. Mr. Pillay suggested that our courts should have the jurisdiction to hear civil cases, to hear the applications where the victim of the harassment is outside Singapore at the material time and where the act of harassment by the harasser is committed outside Singapore. The basis of the court's jurisdiction is set out in Section 17 of the existing POHA. That doesn't change, and we acknowledge that this limits the scope of jurisdiction in respect of acts which may take place overseas. I'd like to turn to the enhanced protection for victims of harassments and related persons. There were questions arising relating to the measures that are available to enhance the protection for victims of harassment, in particular victims which are intimately related to the harasser. All victims, whether married or not married, of whatever gender, will be protected under POHA. So to Mr. Singh's point, the remedies are gender neutral. Dr. Chashilu asked if it's possible to introduce stronger deterrent measures to enforce protection orders. He has also asked if more can be done to prevent subsequent harassments or attacks. The bill has several measures designed to deal with this. 2 of them are deterrent in nature, and the third seeks to try to address the underlying cause or reason for the harassment conduct in the first place. Let me just briefly explain these 3. The first deterrent measure is to make breaches of the POs arrestable in prescribed circumstances. I mentioned that in my earlier speech, especially in a case where hurt is involved or where the harassing conduct persists even after the PO has been issued. In these 2 cases, the breach of the PO is made arrestable. Previously, they were not, and that might have accounted for why some victims felt reluctant to step forward. The second deterrent measure is to have enhanced penalties for offences which involve a second or subsequent breach of the PO and EPO. Clause 11 in this regard of the bill doubles the maximum penalties prescribed if a POHA offence is committed against an intimate partner or against a vulnerable person. The third measure seeks to address the underlying root cause of the harassment. As Dr. Chia pointed out, there may be cases where the accused could not be acting rationally or thinking straight or behaving with restraint. We fully agree with this, as it also mirrors the feedback given to us by the various stakeholders. Currently, separate criminal proceedings have to be brought so that a mandatory treatment order can be granted upon a criminal conviction. We are now empowering the court to consider upfront, where appropriate, for the respondent to undergo psychiatric assessment and treatment after it grants a PO in civil proceedings. So at the juncture that the court considers that it's appropriate to grant the order, it also has to look at whether or not psychiatric assessments and treatments might be necessary for this accused person. In my view, this benefits the accused person, as early psychiatric intervention may help to prevent further harassment where the harassment is due to this underlying psychiatric condition. Ms. Anthea Ong observed that harsher punishments are not necessarily and always an effective deterrent and may not serve victims better. We agree that increased punishments alone cannot be the only solution, and indeed it is not the only solution. POHA is not only about punishing offenders, and as I mentioned earlier, apart from the mandatory treatment orders, psychiatric assessments, it also provides already for options for mediation and counseling, and these are designed to ensure as far as possible that the process, where possible, keeps acrimony, keeps the aggravation to a minimum. Mr. Patrick Tay asked for examples of situations where the enhanced penalties might not apply to a harasser in an intimate relationship. Let me first explain the framework within which the enhanced penalties for offences against victims in intimate relations are meant to apply. Clause 11 sets out a non-exhaustive list of factors that the court may have regard to when determining whether an accused person and the victim were in an intimate relationship. The list mirrors that introduced by the Criminal Law Reform Bill yesterday in respect of certain penal code offences committed in the context of intimate relations. This bill seeks to enhance protection for victims who are psychologically manipulated or intimidated by their intimate partners. For some of these victims, stepping forward to seek help in the context of that relationship is very challenging. And for other victims, sometimes seeking help is not even an option at all. On the one hand, there's a need to protect such victims, but equally, and on the other hand, we should ensure that not every offender is subject to enhanced penalties merely by reason of being in an intimate relationship. So the bill strikes a balance. If the accused persons can prove that the victim's ability to protect himself or herself from the accused was not adversely affected by reason of the relationship, then the enhanced penalties will not apply. That provision is set out in the bill. So on Mr. Tay's example, if there is no evidence before the court that there was an imbalance of power in the context of the relationship, with one party being coercive, the other party being submissive, and no evidence that the victim was unable by reason of the relationship to prevent the harm that was caused or will be caused, then if an accused person commits an offence under POHA in this kind of scenario, the enhanced penalties will not apply. Dr. Chia asked for some recent data on the effectiveness of POs, the number of cases of repeated breaches and the subsequent injuries or death. Since POHA came into force on 15 November 2014, 406 POs and EPOs have been made. In the same period, 51 magistrates' complaints have been filed for alleged breaches of POs and EPOs. In 6 out of these 51 cases, there was a breach of a PO on an EPO on more than one occasion. These statistics give a snapshot, but in themselves cannot be considered to be an accurate barometer of the effectiveness of the POs. Mr. Murali Pillai has raised a query which also pertains to the effectiveness of POs, and let me just try and address that with reference to the example that you cited. He has shared an example of a female victim who obtains a PO against an ex-boyfriend who has harassed her using intimate recordings that he possesses. He has sought clarifications about whether Section 12 prohibits the court from making ancillary orders that it deems fit. The short answer is Section 12(3) provides that a PO may include any requirement necessary for or incidental to the proper carrying out into effect of the order. So it gives the court some flexibility to consider all the facts and determine what's the appropriate remedy in the context of that case, given that no two harassment cases will have similar facts. Mr. Tay suggested that the scope of public service worker under the Act be reviewed. In particular, I think Mr. Tay suggested that private security guards be accorded some protection or special protection under POHA. We had considered this point before, and I think Mr. Tay is aware that this issue had come up in this House previously. To explain the current position, the individuals are considered public service officers, public service workers for the purposes of enhanced protection under POHA if their jobs serve the general public and not just patrons of a private business or establishment. We note the points that Mr. Tay has made. Minister for Law had in 2014 said that the precise classes of workers covered should evolve as the operating landscape of public service evolves over time. I'd like to assure the member that with these amendments, there are sufficient measures and remedies under POHA for the protection of everyone. Offenders can also be prosecuted under the Penal Code for egregious cases involving hurt, criminal intimidation, or criminal force. Also on the issue of harassment at the workplace, Ms. Ong asked whether entities now have a responsibility to exercise reasonable care to prevent and correct the harassing behavior of their employees. In general, employers already have a duty to ensure the safety and health of their employees at the workplace. The amendments that we are proposing in the bill today do not change that. Indeed, the Tripartite Advisory on Managing Workplace Harassment, which was issued in 2015, stands as a practical guide and does so till today for employers and employees to better prevent and manage harassment at the workplace. I would add to this that the bill provides that entities can be criminally liable for all the offences under POHA. So it applies to entities as well as to individuals. And for entities, because they are non-natural persons, the principles of attribution will apply. So, for example, if the officers managing a company instruct their employees to carry out acts of harassment, such as harassment in connection with money lending activities, the company itself can be criminally liable for those acts. The amendments will therefore discourage entities from using or allowing their employees or several employees to harass their customers. Mr. Pillay also raised an example of a disgruntled person who harassed the employees of a company by sending them repeated emails and also using threatening language. I think that's a case that went before the courts some years ago. He suggested that the company be allowed to commence an action to protect its employees from the harassing conduct of such a person. The remedy does lie in Section 12. The starting point is that Section 3 of POHA, which makes it an offence to target a person, which can include a company, and cause any other person, which can also include the company's employees, to suffer harassment, alarm, or distress. So, as illustrated by Mr. Murali's example, the company and its employees are both victims for the purposes of Section 3 in POHA. The company can apply for a protection order under Section 12. As the company is an entity, such a protection order would also extend to its employees. Mr. D'Souza asked about the definition of the term statement of fact and if it is meant to be different from how the term is currently understood under Section 15. The answer is no. Clause 3, which contains a definition of statement of fact, is merely intended to make the definition of the term clearer. I think on this, Mr. Singh also asked a question about the black metal ban. And I forget the precise language that he had used about the phraseology. But from what I caught of the statement, it was an expression of an opinion as to the effects of attending a black metal concert. Now, whether you agree with that or not is a different issue. But as I've mentioned at the start, a statement of fact does not include a statement of opinion or a commentary or even a critique. Stating an opinion without more that black metal bands incite people to do violence, which I think is the thrust of the statement you mentioned, would not be a false statement of fact. Mr. Yicha Singh has 3 queries relating to entities that are the subject of falsehoods. And let me just address them quickly in turn. First, Mr. Yi asked whether the Protection from Harassment Court, PHC, may award damages to a victim of false statement without the victim bringing a civil suit. The answer is no, and that is because the remedies under POHA seek to protect individuals and entities against false statements of fact by preventing or limiting the spread of those false statements. Remedies such as correction orders and targeted correction orders are also available to ensure that the false statements are corrected and made known to those who had viewed the false statement. These remedies are intended to supplement and not replace the existing civil actions for defamation and malicious falsehoods. However, Clause 20 of the bill allows the victim of a falsehood to commence related civil proceedings in the PHC. This will allow the subject of the falsehood to seek remedies provided under POHA, as well as for damages under civil proceedings in one court. So it makes the proceedings a lot more simplified and a lot more convenient. Second, Mr. Yee has asked if a victim of a falsehood only needs to make a police report and, I think in his words, piggyback on criminal investigations in order to obtain an order in relation to the falsehood. Again, the answer is no, and that's because the deeming provisions which allow a respondent to rely on a prior criminal conviction apply only in relation to applications for the PO or the EPOs. They do not apply where a Section 15 falsehood is concerned. Finally, the simplified process and quicker timelines that I spoke about earlier, they're meant to make it less costly, easier for a victim to seek redress, and in answer to Mr. Yee's third question, that's the purpose of the amendments, to simplify, to expedite, to make it easier. And I think to Mr. Singh's point, these simplified procedures also apply to falsehoods. Mr. D'Souza asked further whether the word harm in Section 16AA is limited to physical harm, and the answer is no. For context, a court must first be satisfied in such an application that there is prima facie evidence, amongst other things, that a publication of the specified material has caused or is likely to cause the subject of the false statement harm. An interim order under Section 16 can be made only if it is just and equitable to do so in the circumstances. The harm need not be physical. It may be harm to the subject's reputation or business. It may also encompass emotional harm. And as we know, the nature of online falsehoods is that their effect often extends beyond the realm of physical harm, moving down to reputational or emotional harm. And indeed, the examples that we've heard in the House today by members illustrate that where entities in particular are involved, the harm is often to their reputation or business. Mr. D'Souza also asked about third-party expenses in complying with and adhering to general correction orders. Clause 20, which introduces the new Section 16CA, allows for costs reasonably incurred by third parties in complying with a general correction order to be made against any of the following: the author of the false statement, provided that the author authorized or caused the statement to be published, any person or entity that intentionally published the false statement, and the applicant of the order. I think Mr. Singh also asked if this was intended to apply beyond the general correction order. The answer is no. The reason for Clause 20 is because the general correction order brings in third-party platforms, which has got nothing to do with the publication, the authoring of the statement, and it's not the author itself. And it is in that situation that a cost remedy and regime is provided for in this bill. That is not to say that this otherwise takes away the victim's ability under civil law to seek redress, and that can include the cost of any suffering incurred by the victim against the publisher or by the author of the falsehood. I think Mr. Singh also asked about liability of third parties, and let me just maybe deal with that. I think it's in the context of moderators of social media groups and platforms for posts made by users. The position is that if the user made a post which falls foul of the law on doxing, the moderator will not ipso facto be liable for doxing, since he himself has not published the information. And Mr. Singh's own example, as I understood your example, having heard it, there was also no intention to harass in that case. I turn now to deal with Ms. Lim San San's queries, and there were two queries that I think came through. The first is, what is the estimated volume of online falsehood cases that could be brought before the courts after the bill is passed, and how significant an administrative cost this will be in the context of internet intermediaries. On the first point, the courts are equipped to deal with any increase in the number of cases brought. In fact, I would say the point goes beyond just numbers. If by these amendments we allow more victims to more quickly and more easily obtain redress, resulting in more cases being brought, then in some measure the purpose of these amendments would have been fulfilled. In terms of the administrative cost on internet intermediaries, we should first bear in mind the fact that the internet intermediaries already fall within the scope of POHA today. So it's not a new amendment to bring these intermediaries within POHA. And the starting point is that protection orders, as well as orders under Section 15, can today already be made against these intermediaries. Given this, we do not expect that the revised regime will impose significant additional administrative costs on these platforms. In any event, we should remember that this bill deals with harassment, physical and online, and the use of falsehoods to affect and damage people's lives and livelihoods. Apparent from the many examples I gave in my speech earlier, and certainly those cited by members themselves, this kind of conduct has very serious consequences. People's lives and reputations can be easily and quickly destroyed. Businesses can be ruined, causing economic damage. And all of this happen in an online environment and on platforms where falsehoods travel quickly and the truth is often left behind. Without redress and the remedies which this bill proposes, it will be next to impossible for individuals to protect themselves against this. Internet intermediaries have long been unable, or perhaps unwilling, to take proactive steps to remove such content. So the issue here is not so much about cost. It is about a falsehood. It is where it is not only the right thing to do under this bill to get redress for the individual, but I would say it would also be socially responsible for internet intermediaries to remove these falsehoods and ensure that there's proper redress. So this bill provides legislative solutions to deal with such conduct and to provide individuals with recourse and redress in an environment where the internet intermediaries wield such power and control over the medium. Ms. Lim San San has asked whether the new regulations will harm Singapore's pro-innovation environment. They will not. Ultimately, the strengthened falsehoods regime under POHA will complement the company's interest in running a responsible and positive platform, which serves to improve the quality of private discourse amongst the users and improve the quality of the experiences of users on the platform. We will no doubt continue to work with the internet intermediaries to develop operationally feasible solutions that can be taken into account under the new Section 16BB3 in the bill, which Clause 20 introduces. I turn now to some questions on online harassment and the anonymity of harassers. Mr. Tay in particular raised the issue of anonymity in cyberspace, the identification of online perpetrators not being so easily done. This issue of identifying such perpetrators was also raised during the second reading of POHA back in 2014. The problem of online anonymity is not unique to offences under POHA. Indeed, it is a serious and growing problem, not just in POHA. Law enforcement agencies worldwide have had to face challenges in tackling cybercrimes and cyber-enabled crimes, where criminals have sought to hide behind relative anonymity of the internet to cause harm to society. However, a person who uses a fake moniker or other means to conceal his identity can still be identified by the investigation efforts of law enforcement agencies. The amendments to POHA are intended to provide tools to deal with the unique nature of online falsehoods. POHA currently provides that whether respondent or publisher is anonymous, they may be identified by an internet location address, a website, a username, an account, or an email address, or any other unique identifier as the court may order. With the amendments, even if the source of falsehood is, for example, hiding behind a VPN address and it cannot be tracked down, is anonymous, or refuses to take down the falsehood, the victim has other options aimed at stopping the falsehood, the spread of the falsehood, and also making the appropriate corrections. The victim may apply for a stop publication order to require other parties to stop publishing the false statement or substantially similar statements. In addition, or in the alternative, he may also apply for a disabling order or a targeted correction order, depending on what is the right correction to deal with and address the false statements. These latter orders can require Internet intermediaries to disable access to the falsehood or to ensure that corrections are distributed to those who access the falsehood. Ms. Rahayu asked questions about challenges involved in preserving evidence, especially online ones, where the content could be posted on Instagram stories, where the material is sometimes transient. Features such as what Ms. Rahayu has mentioned are ephemeral and cannot be viewed once a certain period of time has lapsed. Again, that's a challenge to preserving the evidence, but that's also not unique to POHA. While the evidence can be obtained through the investigation efforts of law enforcement agencies, victims and applicants can obviously also take practical steps to preserve the evidence. For example, if a victim or a victim's acquaintances come across offensive content on such platforms which disappear after a certain period of time, he or she can take a screenshot and try and preserve the nature of the content so that they can be used subsequently as evidence. I turn now to the doxing provisions, and as I have heard the speeches, there have been unanimous support for these new provisions. Members such as Engineer Lee, Dr. Chia, Mr. Gantiampo, Madam Rahayu, Mr. D'Souza, Mr. Singh, Mr. Ng, Mr. Walter Teixeira, and Ms. Lim San San have all spoken about or raised the issue of online vigilantism. Let me deal first with the question of what constitutes identity information, which I believe some members have raised. Briefly, it is information which on its own or with other information identifies or could be used to identify an individual. Mr. Louis Ng asked in particular as an example, if a vehicle plate number could fall under the definition of identity information. The answer is yes, it could, since it is information that can on its own or possibly with other information identify an individual. But as with all cases before our courts, the judges will have to look at the specific facts and overall context of each case, to look at the circumstances in which it took place, to look at the holistic context of the facts and circumstances, and then make an overall assessment. Madam Rahayu, Mr. Murali Pillai and Mr. Louis Ng, as well as Mr. Singh, have also raised queries pertaining to the ambit of the offences. So let me address that. I will outline the type of conduct that these offences target, as well as the conduct that will not breach the law. The offence of doxing requires the ingredient of the publisher's intention or knowledge based on the objective circumstances. It is fact-specific, and as is the case with many other intention or knowledge-based offences today, for example, even under POHA, which you can find in sections 3 and 7 of the existing Act, the court must look at all the facts and circumstances before it determines if there was such intention or knowledge. So it's not looking at an overt act like stalking. So some examples are set out in the Act on stalking. But it is looking at circumstances from which one infers or derives an understanding of the intention behind the Act itself. The law provides in the bill for a defense of reasonableness. This means that if a person can prove that his conduct was reasonable, he will not be guilty of the offences. Mr. Ng and Ms. Rahayu asked about the factors which the court might consider when deciding whether there was intention or knowledge present in the case. As I mentioned earlier, and I think you've heard me say, it's fact-specific, so we can't quite constrain the court to always be considering a set of facts and circumstances, but to the extent helpful and illustrative, let me just set out some of these facts which could be considered in a case to determine intent or knowledge. So, for example, words or actions that accompany the publication of someone's personal information. Overt acts and declarations are essential facts from which the court may infer that intention. So if, for example, A publishes B's personal information and encourages others, along with the publication, to harass B or to find a way to incite violence or to use violence against B, then the court could infer that there was the necessary intent in this case. Second, the court will also look at the context in which the personal information was made available. So, in another example, if A supplies B's personal information in an online forum, and I think this is close to some of the examples that members have cited, supplies information in an online forum that is dedicated to hunting down and committing violence against wrongdoers, in inverted commas, the objective circumstances would point to the inference that A knew or had reasonable cause to believe that his post would facilitate the use of unlawful violence against the victim. So the act itself may be neutral, but the act of putting it in a forum which is for the self-declared purposes of trying to seek online vigilantism or to incite violence, that will then be taken together. So the relevant context behind the act will also be considered. The provisions do not distinguish between the original publisher and someone who then reposts the publication. Rather, the law looks at the intention of the person who publishes the personal information or the knowledge that he had when he published that information. So again, to illustrate, the original publisher of the personal information might not have had ill intent, but someone who reposts the same information may then have the malicious objective. The key factor is the intention behind the publication, whether original or the republication, and each case will have to be considered on its own facts. I think Mr. Singh also asked about a hyperlinking occasion, and again, I didn't quite get the specific facts, so please correct me if I'm wrong. But I understand Mr. Singh's example was if you hyperlinked identity information, and I think in the context of the example it was a lawyer, and the question that was posed is why is the lawyer behaving in this way, then on those facts, it's not a question of doxing, it's really a question of trying to show that you might have some queries over the conduct, but there is no otherwise, from your example, an intention to cause harassment to this individual. I would add that posts which merely state opinions or which are meant to encourage social debate, for example, do not fall within the ambit of offences. I will conclude my responses to the queries raised regarding the ambit of doxing by emphasizing that the nature has to be very fact-specific. We cannot be overly prescriptive in the bill, but we want the court to be able to look at each fact, look at each case, understand the context and circumstances in which it is done, and bear in mind that for a person to be prosecuted under this offence, it has to be established beyond any reasonable doubt that the intention of the posting or the publication was to cause the harassment. Mr. Ng, I think, asked if we could categorize and put together examples of permissible and impermissible publication of identity information through guidelines or other information material. As I mentioned, because it is very heavily fact-specific, it may not be meaningful to set them out into a set of compendium or guidelines to try to guide each case. Whether something is or is not an offence will have to be dependent on the facts, and as I said, the court needs to look at each case on its own. But as I also mentioned at the outset, putting all of this together into one body and to allow a framework within which a prosecution can take place will in itself over time develop a body of jurisprudence, and the application of the provisions will be guided by the courts which look at each case and develop the jurisprudence in common law as the cases move along. Let me just deal with a couple of other points. I think Mr. Singh asked, why does POHA not apply to the government? The general position in law is that the government is not bound by legislation unless it expressly provides for that to be so. In the case of POHA, that is the case. And the government has taken a view that it will not avail itself of remedies under POHA, and likewise, it will not be subject to the provisions under POHA. As to how government officers or officers of the government can be held accountable, that can always be done in the usual forum, like in Parliament, as is the usual case. And I think Mr. Singh is aware of that. Let me just see if there are other queries I had missed out. Mr. Speaker, I believe I've dealt with the queries raised by various members. I'd just like to reiterate that As important as it is to have this piece of legislation to deal with remedies for harassment online and offline, equally important is the social consciousness and, of course, public education to shape behavior. I've taken note of members' suggestions which may be outside of the scope of legislation, but which are nonetheless helpful as we work towards a society that, not just through legislation, but as a whole, frowns on harassment and frowns on what is effectively bullying, whether online or offline. We have worked and will continue to work with the media and other stakeholders to raise general public awareness of their rights and remedies under this bill. Mr. Speaker, I beg to move.
Mr. Pritam Singh.
Thank you, Mr. Speaker. I just have one clarification, but before that I'd like to thank Senior Minister of State for going through the examples that were raised and providing his clarifications for them. My query really is on the definition of a false statement, and the example that I used, which SMS referred to as an opinion, went like this: people who listen to black metal music may commit violence in the real world. Now, I can understand in the context of a false statement, there are usual objective tests in law, and that ostensibly may not qualify as a false statement. But in Clause 3, the definition of a false statement includes a misleading statement. And that complicates the situation a little bit vis-à-vis whether that is an opinion or whether that's actually a misleading statement. Now, if it is a misleading statement, then an individual who made that statement potentially could have action taken against him under the bill, of course, through the civil route. Can the SMS please clarify?
Thank you, Mr. Singh. A misleading statement is still a statement of fact, and it is not a comment or opinion. The example you cited, may commit violence if you attend a black metal band, is a view that has been formed. It's a culmination of various factors which have led a person to come to the conclusion. That's not a statement of fact, nor can it be characterized as a misleading statement, which is also a statement of fact. So those are outside, that statement that you cited is outside of the realm of this bill. What this bill seeks to do is to look at statements of fact which are directly and positively false, and I think the courts have very clear jurisprudence on this, but also indirectly through omission, otherwise false or misleading in itself. In my earlier speech, I cited an example as to how if you omit certain key facts which are material to an understanding, then the image or the view that has been communicated is otherwise false because of the omission, and not so much because of a positive statement. So the bill covers both scenarios.
Mr. Yichar Singh.
Thank you, Speaker. In terms of doxing, I'd like to ask the SMS, if someone is wrongly identified as a person in a viral video, and then he goes on to identify the correct person, is he also guilty of doxing?
Well, it depends on the circumstances in which he went on to identify the actual culprit. But I would imagine that in such a scenario, you remember I spoke that there's a defense of reasonableness. So if you portray someone as being the perpetrator when actually it is not, then I think I would doubt that a court would say it's unreasonable for the person to then point into the direction of the actual perpetrator. But as I said, it's fact specific. Let the court look at the facts of each case and understand the context and reasons behind the posting, even by the second person.
Mr. Patrick Tay.
Just a point of clarification, SMS. You mentioned about government being precluded from using the POHA to take action. Just for clarity, individuals, in particular public sector workers or civil servants, they can actually make use of the POHA vis-a-vis versus perpetrators, or they themselves are perpetrators. Am I right?
For these individuals, yes. And I think I explained that in my earlier speeches on your example on workers.
Mr. Pritam Singh.
SMS, just to follow up on that earlier example vis-à-vis the misleading statement. I understand what SMS has said about it. The issue is, in that context that I provided, that statement has caused damage to a certain entity. and that entity seeks to prove in court that that statement actually in and of itself is misleading, and because of those circumstances, loss has accrued to the band, would they be able to rely on POHA?
No. If it is not a statement of fact, then POHA doesn't apply. But that's not to say that should you have a statement that has affected a business entity economically, or that might otherwise be defamatory of an individual, those civil remedies still apply, and parties can still avail themselves of that even if the statement doesn't fall under POHA. I hope that clarifies.
The question is that the bill be now read a second time. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Protection from Harassment Amendment Bill.
Committee stage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 32 stand part of the bill. As many as are of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Law.
Mr. Speaker, I beg to report that the bill has been considered in Parliament and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Protection from Harassment Amendment Bill. Item 2, Protection from Online Falsehoods and Manipulation Bill, second reading.
Order. I propose to take a break now. I suspend the sitting and will take the chair at 15:45 hours. Order. Order.